Developing a national position on cyberspace allows a state to make clear its stance on the application of international law in the context of cyber activities. And after a state decides to go through the process of drafting its own national position, it needs to then decide exactly what substance to include in that document. The Handbook on Developing a National Position on International Law and Cyber Activities is a guide to help states to consider what substance their positions might contain. That substance might include a lot of small legal details, but big picture, just why would a state want to make public the substance of its national position?
To answer that question, I think we need to go one step back and ask ourselves what the function of law is to begin with. And the function of law is to structure a society, to give expectations of actors of how to behave. So if you put 200 states together and ask them what their position is about the application of international humanitarian law on cyber operations, you may get different answers. And for people like me, military legal advisors working for the armed forces, you need clarity. Whether it's when you're working in operations under high pressure and commanders want to have an answer right away, or in research and development, for example in developing AI-driven malware, or in policy. Regardless of where you work as a military legal advisor, you need clarity on the law and a national position of your own country and that of those that you're working with can be vital, just to have something you can rely on.
So the handbook, it does a number of different things, but one of them in the substantive chapter, the chapter on the substance of international law, it maps out the substantive legal positions that have been taken by states. So what this means is it maps out the specific legal views that states have taken on issues like sovereignty, like non-intervention, like the use of force. And by mapping out, you can see where the points of convergence lie, in other words, what states agree on, but also, if you are mapping the views, you also see the areas of divergence. Yeah, so for example, with the question of sovereignty, we see that not all states agree that this is a standalone rule, and these different views then have repercussions on how cyber operations like those that we discussed are qualified by international law.
Whether or not we have agreement or disagreement, debate is important. And it is good to have a diversity of views. It's good to have opposition. It's good to have debate. And national positions can really foster that debate. 33 states have issued national positions so far, and they have included a pretty consistent list of subjects in national positions. They have covered, for example, sovereignty, non-intervention, due diligence, peaceful settlement of disputes. However, the actual way or the actual position that states have taken on these various topics has varied. So the handbook tries to nudge states to come together and to discuss those issues in order to address them.
Just knowing what the other states in your alliance think about a certain topic is already important. In the end, it will strengthen the law, also the function of certain legal regimes. I mean, IHL is there for a reason. It helps to find the right balance between military necessity and humanity.
So, the substance of a national position is helpful for clarity between countries and even cooperation. But how can a state format the substance of their national position to make it as effective as possible? Watch the next film to find out.